Most asylum declarations I review are so weak that the case is lost before anyone even steps into a courtroom. One vague line or missing fact, and the judge can preterm it or deny the claim without an opportunity to present any other evidence. And the worst part is that many applicants think they told their story, but legally they gave almost nothing the court can actually use. In this video, I will walk you through the 5 red flags I've seen too many times to count and how to fix them. I'll use anonymized real case examples so you can see the difference between a declaration that fails and one that actually wins cases. But before we begin, if you're new here, my name is Julio Costa and I'm a senior immigration paralegal. I've been focused in removal defense for the past 5.5 years, and a big part of my job includes working in asylum applications. I've drafted and reviewed hundreds of declarations for cases before EOIR and the BIA. I've seen what makes a declaration useful and what gets people denied. But here's a quick note. This is an educational video, not legal advice. Every case is different. So if you need help with your specific situation, speak with a qualified immigration attorney. Now let's talk about why the declaration is the backbone of the case. For immigration judges, the declaration is often the first and clearest window into your client's claim. Before anyone testifies, the IJ is already forming a view based on what's written. And here's what most people don't realize. If the declaration doesn't outline the essential elements of an asylum claim, the judge can preterm it, which means they can deny the application without a full hearing. No testimony, no explanation, straight to removal. That's why at a minimum, the declaration needs to show that your client suffered or feared persecution, that the persecution was because of a protected ground, that the persecutor was the government or the government was unable or unwilling to protect them, and that there's a real risk it could happen again if that person returned to their home country. Bottom line, a declaration isn't just telling your story, it's telling it in a way that meets the legal framework the judge actually applies. With that in mind, here are the 5 biggest mistakes and how to fix them. The first major problem is what I call the diary tone declaration. Most asylum applicants are traumatized, but asylum isn't just granted because their story was sad. Diary tone statements fail because they leave out the facts judges actually decide on, such as who targeted you, when did that happen, what exactly happened, and why did they target you. Here's the contrast. In a weak declaration, you'd read something like this. People threatened me many times because of my religion. In a strong one, you'd see something like, on May 22nd, 2018, 2 men wearing the militia armband confronted me outside my home. One said, if you keep leading those church meetings, you will disappear like Pastor Daniel. I recognized one, he works for the municipal police. That version gives date, actors, quote, motive, and police link. That's the level you need. You're not writing literature. You're mapping facts to the legal element. That's how you turn a story into evidence. The second problem is timeline chaos. The declaration jumps from 2016 to childhood to 2019, then back again. That or the dates don't match the I-589. When that happens, the IJ starts questioning credibility. Not because the story is false, but because it's disorganized. And on the stand, even one mismatch becomes an inconsistency, which can warrant an adverse credibility finding and ultimately lead to a denial. The fix is simple. Just tell the story chronologically. I use 3 phases. 1, before the harm, to provide context. 2, the escalation with key incidents. And 3, the aftermath, detailing the consequences and ongoing risk. And for each incident, use this microstructure. Date, place, actors, what happened, and the outcome. Here's a weak paragraph. People came to my house several times. Later, they attacked me, then they threatened my brother. Let's improve it. In or around March 2019, 2 men with militia armbands came to my home in São Paulo and told me to stop posting about politics. 2 weeks after that, the same men attacked me outside my workplace, punched me, took my phone, and warned that the next time I wouldn't get up. Now the IJ can follow escalation, and it aligns with the I-589 and testimony. A clean timeline protects credibility. The third major failure is what I call Nexus fog. The declaration never makes it clear why the applicant was targeted. This is the core of an asylum case. You're not just showing that something bad happened. You're showing why it happened. If the motive isn't clear, judges treat the harm as random crime, generalized violence, or a personal dispute. Any of those almost always result in denial. Nexus failure sounds like this. They attacked me because I'm gay, or they threatened me because of my religion. That's just a conclusion. No evidence, no statements, no indicators of motive. The court needs facts that point to the persecutor's reasoning. To fix this, show what the persecutor said or did whenever possible with direct quotes, slurs, and notes or messages. Demonstrate differential treatment by answering whether others were treated the same or your client was singled out. Here's a weak sentence. They attacked me because I'm a Christian. This is what it looks like when you ask and include details. During the attack, one shouted, "You and your church are ruining this town. If you preach again, we'll burn the house with you inside. My neighbors who are not Christian have never been threatened." Now we have a direct quote, clear motive, the protected activity, which is preaching, and comparator evidence. Here's a quick task for you. If you erased the protected ground from the story, would the harm still happen? If the answer is yes, the nexus is weak. If the answer is no, the nexus is strong. A declaration without nexus isn't just incomplete, it's dead on arrival. The fourth problem is what I call the government failure gap. Many declarations say something like this: the police do nothing, or the government never helps. Again, that's just a conclusion. It doesn't prove anything. To qualify for asylum, you must show that the government was the persecutor or that it was unable or unwilling to protect you. If you don't establish one of those, the case collapses, even if there's severe harm. Judges look for information on whether your client reported the harm, what happened when they did, if they didn't, why not, and whether the explanation makes sense given country conditions. Here's what a weak declaration says: I went to the police, but they didn't help. A strong one, on the other hand, would go something like this. On July 11, 2019, I reported the attack to the 4th Precinct in São Paulo. Officer Rocha refused to take a report and said, "We don't get involved when the PCC is involved." He told me to leave. That gives date, place, actor, quote, and implicit corruption. And if the client didn't report, that can still be fine, but the declaration must explain why. For example, the militia controls the police. When my neighbor tried to file a report last year, officers arrested him instead. That's why I didn't report. You would have put me in more danger. That fits real-world patterns we see constantly. You need to explain to the judge why the government was involved or complicit. Skip that, and even a strong case can fail. The fifth mistake is what I call the future fear void. Many declarations describe what happened in the past, and then it stops. But asylum is forward-looking. Past persecution can qualify you, but the system still asks, is this person still in danger today? If the declaration doesn't explain the ongoing risk, DHS or the judge will use it against you. This is weak. They attacked me in 2019 and I left. Here's a strong draft. After I left in 2019, the same man continued visiting my parents every few months, asking where I went. In March 2023, they told my brother that if I return, they will finish what they started. The militia still controls our neighborhood and tracks people through relatives and church networks. Here's some key points were hit: the continued interest, capability, recent threats, and same actors. That's what keeps the claim alive. Now, connected to future fear is internal relocation. Even if you suffered past persecution, DHS or the judge can still ask, why can't you just move somewhere else in your country? If your client's declaration doesn't address that, they are vulnerable. A strong declaration explains why relocation is not safe or reasonable. That might include the fact that the persecutor has national reach, they know the client's identity and can track people, or prior relocation failed, persecutors have connections to police or political networks, or people like your client are targeted nationwide. Here's an effective example. The men who targeted me work with municipal police and are connected to the national ruling party. People with my profile have been attacked in other regions. My cousin relocated to Recife in 2022, yet the same group found him within 6 months. They posted my photo online, calling me a traitor. That shows national networks, tracking ability, and continued motivation, exactly what the judge needs to see. Now, to give you a realistic picture of how immigration judges respond to weak declarations, here are some examples of the actual type of language I see in written decisions every day. These are paraphrased and anonymized, but reflect real case reasoning. Read part of this decision with me and let me know whether you can identify the issues. Respondent states only that men threatened me because of my religion, but provides no description of what we said, when the threats occurred, or how the assailants knew respondent's beliefs. Without such details, the court cannot conclude the harm was on account of a protected ground rather than ordinary criminal activity. That's right, the issues here were in the failure to provide details and the nexus. Now check this one out. The record does not indicate that anyone has attempted to contact or harm respondent since departure, nor does it explain why respondent could not reside safely in another region of the country. In this case, the respondent failed future fear and relocation grounds. These short paragraphs show how judges point out missing detail, unclear motive, and lack of ongoing risk, and those gaps become the reason for denial. Nearly every negative finding maps to one of the 5 issues we've discussed. Once you understand how judges articulate these problems, you can draft declarations that respond to them head-on before anyone steps into court. Here's a simple checklist for building a stronger declaration. Number 1, start with a 1-page chronology. If the timeline is unclear, credibility is at risk. Number 2, apply the 5 fixes. Fact-based, not diary style, clear timeline, show motive, why your client, show government involvement or failure, show ongoing risk and lack of safe relocation. Number 3, cross-check with the I-589. Align dates, places, and actors. Number 4, add a concise return scenario. Who will harm your client, how, and why? Number 5, read it out loud. Fix ambiguity and unclear sequences. Simple structure, big impact. If you want to go deeper, I put together a question guide with the same framework I use to help people develop stronger declarations. It walks through the kinds of questions that uncover the facts judges focus on, like dates, motive, government involvement, ongoing risk, and relocation. You can download it using the link below. Just enter your email and it will be sent to you. And if you'd like more videos like this, comment guide so I know this topic is useful. And make sure to like the video and subscribe for more breakdowns on declarations, court preparation, and avoiding other pitfalls. Thanks for watching, and as always, keep your steps steady and your purpose clear.